Thank you very much for all of that. John Dyson calls me the great dissenter, and I'm not sure that that's necessarily meant to be complimentary. It's wonderful to be back at Queen's, especially in this lovely hall. And I've been reflecting ever since Sally was kind enough to ask me to deliver this lecture upon my time both here at Queen's and in the practice of the law. And of course, I recall that on the 29th of September 1970, I believe for the last time as Lord Chief Justice of Northern Ireland, Lord Mcdermott called a group of newly qualified barristers to the bar of Northern Ireland. He was by that time not merely an iconic figure in the legal landscape of Northern Ireland, he was rightly regarded as a colossus in legal circles throughout the common law world. Even then, I felt, as one of those barristers, though perhaps not as keenly as I ought to have done, I felt the enormous privilege that it was to be called to the bar by this great man. I had the added later privilege to have appeared before him a number of times. This was not, I have to say, an entirely unalloyed pleasure. That wasn't because of any lack of benevolence on his part, for he was unfailingly kind to newly called members of the bar. It was rather because of his legendary status. That was more than a little awe-inspiring for a fledgling and not very articulate barrister. I have, I hope, a rather better developed sense of privilege on this occasion. As Sally has said, Lord Mcdermott was a great friend of Queen's, and it was entirely fitting that Queen's should have instituted this annual lecture in his honour. And as Sally has also said, many distinguished lecturers have preceded me to this lectern, and that circumstance, although daunting, increases the feeling of honour that I have in delivering this, the 2013 McDermott Lecture. And it is, of course, an especial pleasure for me to return to this magnificent hall in my alma mater. That pleasure is enhanced because it gives me the chance to pay tribute to my good friend, Sir Peter Gregson, the outgoing Vice-Chancellor. Over the last 9 years, Peter and his team have led Queen's from great success to yet greater triumph. And I'm delighted on this occasion to acknowledge the abundant debt that all the student population, the alumni and the friends of Queen's, and indeed the entire society of Northern Ireland owe him for what he has achieved at this university. The title of tonight's lecture, Human Rights Law and the War on Terror, almost chose itself in light of the nature of many high-profile cases decided either by the Judicial Committee of the House of Lords or the Supreme Court over the past 10 years. But sincere thanks are due to my judicial assistant, Jacob Bindman, for the precise formulation of the title and for his invaluable help in the preparation of this lecture. Because of Queen's generosity, Jacob is here this evening, principally, I think, to ensure that I don't stray too severely off message. But I'm very grateful to him, not only for his help on this project, but for all his efforts to keep me right over the past year. The words in the title to the lecture, The War on Terror, are enclosed in quotation marks advisedly, because, as you all will know, there's more than a little controversy as to what is meant by terror, and even more, perhaps, about the aptness of describing society's attempts to counteract it as a war. But I don't intend to dwell on those aspects this evening. That our society is afflicted by the threat of terrorism, however defined, and that it must take measures to counteract that threat are beyond question. But that very circumstance raises a particular challenge for the administration of justice and for judges charged with defining the boundaries on the state's encroachment on fundamental rights in its efforts to protect national security. As in so many areas of life, approaching this forbidding, redoubtable challenge requires a strong sense of perspective. And that perspective must be informed by, if not indeed positively guided by, a keen understanding of the lessons of history. It's not only Lord Atkin's celebrated aphorism in Liversidge and Anderson, amidst the clash of arms, the laws are not silent, which acts as an inspiration to today's judges in the solemn duty that they have to perform in, again to quote Lord Atkin, standing between the subject and any attempted encroachment on his liberty by the executive, alert to see that any coercive action is justified in law. More recently, that widely respected jurist, Aaron Barak, the former president of the Supreme Court of Israel, issued this cautionary and sobering warning. He said, "A mistake by the judiciary in times of war and terrorism is worse than a mistake of the legislature and the executive in times of war and terrorism. The reason is that the judiciary's mistakes will remain with the democracy when the threat of terrorism passes, and will be entrenched in the case law of the court as a magnet for the development of new and problematic laws. This is not so with the mistake of the other branches, which can be erased through legislation or executive action and usually forgotten." The pressures, whether they be overt or subconscious, on judges making decisions about the lawfulness of measures taken by governments at times of national crisis or where a real terrorist threat is evident, those pressures are considerable. And if truth be told, those pressures have on occasions, because of the exigencies that have been perceived to exist, those pressures have proved impossible to defy. Justice Brennan of the United States Supreme Court, writing in 1988, observed that the United States judiciary had a poor record of upholding civil liberties in times of crisis. He said that the courts had consistently produced sophisticated jurisprudence on the rights of citizens in peacetime, but had a poor record in defending those principles when crisis occurred. This is what he said. After each perceived security crisis ended, the United States has remorsefully realized that the abrogation of civil liberties was unnecessary, but it has proven unable to prevent itself from repeating the error when the next crisis came along. And Brennan thought that a key reason for this failure was the episodic nature of national crises. Paradoxically, perhaps, he felt that there hadn't been the opportunity to develop more measured and robust judicial responses to threats to civil liberties because there hadn't been a sufficiently sustained period of threat. He thought that a more long-lasting time of crisis would have allowed jurisprudence to evolve, which was more resilient to hysteria and unthinking reaction. Like many other commentators, he felt that fundamental principles must be able to stand firm against attacks made upon them in the name of necessity and expediency, and he felt that that had not always been achieved. Now, of course, it's an unwelcome irony that today we have an enduring threat to democracy and national security in the form of terrorism that seeks to strike at the very fundamentals of our society. So the platform for the development of that robust corpus of jurisprudence that Justice Brennan had in mind is now in place. So how have we as judges measured up to that challenge? Well, of course, contemporary judgment on an issue like that is as invidious as it would inevitably be fallible, and I will not attempt it. History will judge, but I do venture that history will have ample material for the judgment. The most that I think that I can do in this lecture is to choose and to say a little about some of the cases on which that judgment of history will be based. In the United Kingdom over the last 10 years or so, there has been an almost unprecedented engagement of the courts with issues surrounding national security. Pressure in the post-9/11 atmosphere has been at its most pronounced on the central features of a fair trial. And when one speaks, of course, of the right to a fair trial, many think of a criminal trial. But the reality of the so-called war on terror in the legal context is that for the most part, the battle over fundamental rights has not been fought in the criminal law arena. Thankfully, at least thankfully in my view, the criminal trial has thus far remained largely untouched by the problems of evidence that the state deems too sensitive to disclose. Instead, what has exercised the courts on very many occasions has been the treatment of those whom the state suspects of involvement in terrorism, but either is not able to or has elected not to prosecute. The range of measures that the state has used in relation to such people is extremely wide, and those measures have taken the courts into unprecedented territory. We've had to deal with complex arguments about the legitimacy of procedures which strike at the heart of traditional common law rights. Contrary to popular belief and what one might expect, the Human Rights Act and the European Convention on Human Rights have not always occupied center field in all of those cases. But measures ranging from straightforward detention without trial to asset freezing to protracted attempts at deportation on grounds of national security all have been involved. And into that heady mix is thrown the traditional civil claim where evidence that touches on national security issues brings it squarely into the debate on the right to a fair trial. Now, an obvious starting point in my brief review of the major cases is that of A and others against the Secretary of State for the Home Department decided in 2004 by the House of Lords. Fair trial issues did not, in fact, lie at the heart of the case, but it nevertheless represented the beginning of what might be described as a long tug-of-war between the courts and the executive, as to the rights of suspected terrorists to disclosure of material on which decisions adverse to them had been taken. And a panel of 9 law lords in the Judicial Committee of the House of Lords decided in that case that legislation which had allowed the government to preemptively lock up a number of foreign terrorist suspects in Belmarsh prison without charge or trial was incompatible with the Human Rights Act, and that their detention was, in consequence, unlawful. And in a passage that forcefully summed up the full reality of the scheme, Lord Hope of Craighead said this. He said, "An individual who is detained under Section 23 of the Anti-Terrorism, Crime and Security Act of 2001 will be a person accused of no crime, but a person whom the Secretary of State has certified that he reasonably suspects is a terrorist. The individual may then be detained in prison indefinitely. True it is that he can leave the United Kingdom if he elects to do so, but the reality in many cases will be that the only country to which he is entitled to go will be a country where he is likely to undergo torture if he goes there. He can challenge before the Special Immigration Appeals Commission the reasonableness of the Secretary of State's suspicion that he is a terrorist, but has no right to know the grounds on which the Secretary of State has formed that suspicion. The grounds can be made known to a special advocate appointed to represent him, but the special advocate may not inform him of the grounds and therefore cannot take instructions from him in refutation of the allegations made against him. Indefinite imprisonment in consequence of a denunciation on grounds that are not disclosed and made by a person whose identity cannot be disclosed is the stuff of nightmares, associated, whether accurately or inaccurately, with France before and during the Revolution, with Soviet Russia in the Stalinist era, and now associated, as a result of Section 23 of the 2001 Act, with the United Kingdom. Strong stuff indeed. And notwithstanding, in 2004, the long shadow cast by the events of the 9th of September 2001, the House of Lords unanimously was unequivocal in its denunciation of the legislation. The executive had simply gone too far. Now, the latter part of the passage that I've quoted from Lord Hope's speech revealed the besetting problem that has since been the source of controversy when the state has sought to place restrictions on those deemed to present a threat to national security. Material on which the state wishes to rely but does not want to disclose to the affected party or the wider public has come to dominate the legal argument in the government's attempts to control those that it sees as a threat. Such material is variously described as closed, secret, or contrary to the public interest. Ultimately, however, it concerns evidence that may be used to restrict an individual's liberty, or to remove him from the country, or to defeat a civil claim which he may take against the state, or to control his financial activity. And all of these measures are taken without giving the individual a chance to see or contest the evidence, other than through lawyers appointed by the court who may not communicate with the party whose interests they are supposed to represent. Now, some of the aspects of the case of A and others featured in a subsequent application by the appellants in that case to the European Court of Human Rights in a case that became known as A and others against the United Kingdom. And that resulted in a landmark decision by the Strasbourg Court, about which I have something to say presently. In the meantime, however, as a result of the House of Lords decision, the men who had been imprisoned in Belmarsh were released. Some of those were placed under control orders, a term that we're now familiar with, but which at the time was a novel concept in United Kingdom law. And those control orders sparked a series of decisions in the House of Lords and later the Supreme Court as to what exactly a person who was subject to a control order may know of the case against him. Parliament had legislated to specifically restrict the right to disclosure of evidence for those who were made subjects of control orders. And the principal issue in the series of cases which ensued focused on the requirements of Article 6 of the European Convention on Human Rights and the fair hearing guarantees which Article 6 enshrines. And as part of the new dispensation of control orders, the phenomenon that I've referred to already of special advocates emerged into full flower. These were specially chosen lawyers who were permitted to view the closed evidence on behalf of the suspect. They were allowed to challenge it or to claim that it should be disclosed. But they were not, and currently are not, permitted to discuss the material with the suspect. Notwithstanding those constraints on the ability to represent the suspect, the Secretary of State argued that the introduction of the special advocate scheme into the equation provided sufficient guarantees of procedural fairness for the suspect. And it was the government's position that no further open disclosure was required. Now, the picture that emerged from the various decisions in which battle was joined on this adequacy of disclosure, the picture that emerged from the decisions, I have to say, with the benefit of hindsight, of course, was not entirely free from ambiguity. First of all, in the case called the Secretary of State against MB, the House of Lords left open the possibility that the subject might be given a sufficient measure of procedural protection, even though disclosure of the whole evidential basis for the basic allegation against him had not been made. In a later case, a majority of the Court of Appeal in AF number 2 stated that there is no principle that a hearing will be unfair in the absence of open disclosure to the controllee of an irreducible minimum of allegation or evidence. And so, despite the robust language of Lord Hope in the original decision in the Belmarsh case, those who had previously been locked up now found themselves under very restrictive control orders, but still without much of any knowledge of the case that was made against them. There began to emerge, however, the notion of a core irreducible minimum of disclosure, or as it is sometimes inelegantly called, gisting. And when Strasbourg gave judgment in A and others against the United Kingdom, it held that where a decision to certify suspects as international terrorists under Section 21 of the 2001 Act, with all the consequences that that had by way of detention without trial, where such a decision was based solely or to a decisive degree on closed materials, the procedural requirements of the Convention would not be satisfied. And in rejecting the Secretary of State's contrary argument, the Court went on to say this. It said, the special advocate could perform an important role in counterbalancing the lack of full disclosure and lack of a full open adversarial hearing by testing the evidence and putting arguments on behalf of the detainee during the closed hearings. However, The special advocate could not perform this function in any useful way unless the detainee was provided with sufficient information about the allegations against him to enable him to give effective instructions to the special advocate. So in effect, what Strasbourg was saying was that although the special advocate system could go some way towards mitigating the effect of non-disclosure, ultimately there came a point where, in order to comply with the minimum guarantees of Article 6, sufficient information of the case against him had to be supplied to the suspect in order that he could give informed instruction to the special advocate. That this was the minimum requirement was later acknowledged by the House of Lords in the subsequent case of AF number 3. Now, it may be a matter for debate, but it seems to me that the acknowledgement that the House of Lords made might be seen in retrospect to be no more than one would expect in light of our common law tradition. If someone is to be detained in prison, or if he is to be the subject of a control order which so curtails his liberty as to amount to a form of closely confined house arrest, is it not obvious that he should have the chance to know and to challenge the basis on which the decision so to confine him has been taken? And the answer that is sometimes given, and is frequently given, to the effect that to reveal the basis for detention would imperil national security, that answer, as it seems to me, cannot be without more a complete response. A balance between what at first blush might appear irreconcilable positions has to be struck. And it's true, of course, and I'm the first to acknowledge it, that no perfect solution is possible. But the fact that no perfect solution is possible does not relieve the courts or the executive of the obligation to strive for the solution nearest to perfection that can be achieved. So one might have expected that much of the debate in subsequent cases would have been preoccupied with a quest for that near-perfect solution. In my view, however, that central issue has failed to occupy a center stage. In the case of Al-Rawi against the security services, a case which was heard at the same time as Tariq, to which Professor Wheeler referred in her introduction. In Al-Rawi, the claimants were all British residents who had been rendered and then imprisoned in Guantanamo Bay, as well as other prisons along the way. They all alleged that they'd been tortured in the process. They claimed to have a substantial body of evidence that they wished to put before the court, which suggested that there had been complicity by the United Kingdom in certain aspects of their treatment. The security services, who were the defendants in the action, asked the High Court to order a procedure under its inherent jurisdiction, and that procedure would have allowed the security services to place before the court sensitive material in closed session. In practical terms, that meant that apart from those acting for the security services, the material would be seen only by the judge and by special advocates appointed to act for the claimants. Now, importantly, as approved, there was no statutory underpinning for such a procedure, but the state argued that there was an inherent power for the court to order such a trial. Moreover, it was submitted, there was an enormous practical benefit in that the judge would be able to see all the relevant material, not just that which the security services felt able or felt was safe to be disclosed. And this, it was suggested, would inevitably produce greater fairness in the outcome. The argument was resoundingly rejected by the Supreme Court, and two principles of apparently absolute clarity stood out from the judgments in both the Court of Appeal and the Supreme Court. The first was that a party to proceedings should be informed of the material that would be used to challenge his claim, and that he should have a full opportunity to answer that case in open court. The second principle was that the first principle should not be derogated from unless authorized by unambiguous statutory provisions. In the Court of Appeal, Lord Neuberger, then Master of the Rolls, now the second President of the Supreme Court, delivering the judgment of the court, said this. He said, "The principle that a litigant should be able to see and hear all the evidence which is seen and heard by a court determining his case is so fundamental, so embedded in the common law, that in the absence of parliamentary authority, no judge should override it. A litigant's right to know the case against him and to know the reasons why he has lost or won is fundamental to the notion of a fair trial." And when it came to the Supreme Court, we were no less emphatic in dismissing the Security Service's appeal. Delivering the lead judgment, Lord Dyson said this. He said, "There are certain features of a common law trial which are fundamental to our system of justice, both criminal and civil. First, subject to certain established and limited exceptions, trials should be conducted and judgments given in public. The importance of the open justice principle has been emphasized many times. The open justice principle is not a mere procedural rule, it is a fundamental common law principle." And he continued, "Secondly, trials are conducted on the basis of the principle of natural justice. The Privy Council said in the civil case of Kanda against the government of Malaya, if the right to be had is to be a real right, which is worth anything, it must carry with it a right in the accused man to know the case which is made against him. He must know what evidence has been given and what statements have been made affecting him, and then he must be given a fair opportunity to correct or contradict them." And Lord Dyson continued, "Parties should be given an opportunity to call their own witnesses and to cross-examine the opposing witnesses. As was said by the High Court of Australia in Lee against the Queen, confrontation and the opportunity for cross-examination is of central significance to the common law adversarial system of trial." In my judgment, I dealt specifically with the claim that it was better for the judge to see all the material, even if this was denied to the claimant. And this is what I said about that. The defendant's second argument proceeds on the premise that placing before a judge all relevant material is, in every instance, preferable to having to withhold potentially pivotal evidence. This proposition is deceptively attractive, for what, the defendants imply, could be fairer than an independent arbiter having access to all the evidence germane to the dispute between the parties. The central fallacy of the argument, however, lies in the unspoken assumption that because the judge sees everything, he's bound to be in a better position to reach a fair result. That assumption is misplaced. To be truly valuable, evidence must be capable of withstanding challenge. I go further. Evidence which has been insulated from challenge may positively mislead. It is precisely because of this that the right to know the case that one's opponent makes and to have the opportunity to challenge it occupies such a central place in the concept of a fair trial. However astute and assiduous the judge, the proposed procedure hands over to one party considerable control over the production of relevant material and the manner in which it is to be presented. The peril that such a procedure presents to the fair trial of contentious litigation is both obvious and undeniable. From the Al-Rawi decision, two strong interrelated themes can be seen. The first was that the court could not draw on its inherent jurisdiction to create a closed material hearing which involved the receipt of evidence by the court, which was withheld from another party. Although the court was master of its own procedure, it could not fundamentally alter the system of trial. In particular, it could not exercise its power to regulate its own procedures in such a way as would deny the parties their fundamental constitutional right to participate in proceedings in accordance with the common law principles of natural justice and open justice. The second theme was that for such a radical departure from the traditional rights of parties as was involved in the holding of closed material procedure, that should only come about through the act of a democratically elected legislature. The adducing of evidence by one party and withholding it from another might be technically a matter of procedure, but that did not affect the need for such a fundamental change to citizens' rights to receive the endorsement of Parliament. As Professor Martin Dockeray said in his work, The Inherent Jurisdiction to Regulate Civil Proceedings, he said, where procedure is as important as substance, procedural change requires the same degree of political accountability and economic and social foresight as reform of an equivalent rule of substantive law. Now, in contrast to the position in Al-Rawi, as Professor Wheeler has told you, in the case of Tariq against the Home Office, the Supreme Court, by a majority of 8-1, with mine not for the first time being the lonely voice of dissent, held that it was necessary to withhold from Mr. Tariq information which had led to his summary dismissal from his job at the United Kingdom Border Agency. That decision to dismiss him was stated to have been taken on operational security grounds. He had brought a claim against his employers in the Employment Tribunal for wrongful dismissal on the grounds of discrimination. Now, unlike the situation in Al-Rawi, in Tariq, the Employment Tribunal did have statutory authority to hold closed material procedures and to appoint special advocates, and it duly availed of both powers. Mr. Tariq was told that he had been dismissed because he was closely related to a suspected terrorist, and although there was no suspicion falling on him personally, the United Kingdom Border Agency was concerned about pressure that might be brought to bear on him by relatives and associates who were possibly involved in terrorism. The Supreme Court held that neither the common law nor Article 6 of the Convention required that Mr. Tariq should have disclosure of any of the case against him, not even a gist. And the basis on which this finding was made was that his liberty was not at stake. That didn't appear to me, nor does it, I have to confess, today appear to me to be a difference of critical significance. It seemed to me that there was no principled basis on which to draw a distinction between the essence of the right to a fair trial based on the nature of the claim that was made. A fair trial in any context demands that certain indispensable features are present to enable a true adversarial contest to take place, and those included the claimant having at least a gist of the material that was deployed to defeat his case. Now, as I've said earlier, the second principle to emerge from Al-Rawi was that the first principle, you remember that the first principle was that the court couldn't draw on its inherent jurisdiction to create a closed material hearing. That first principle should not be derogated from unless authorized by unambiguous statutory provisions. Democratic approval, or at least the endorsement of a democratically elected legislature, was therefore deemed essential as a matter of central principle. But pragmatic considerations were also in play here, although they didn't feature perhaps as strongly in the Al-Rabi case as in the subsequent case, again mentioned by Professor Wheeler, of McDermott. The McDermott case was heard by the Supreme Court in March of this year, and judgment has not yet been given, and on that account only limited reference to it can be made. But it is in the public domain that in October 2009, the British government, through the Treasury, made an order called the Financial Restrictions Iran Order 2009, which required all persons operating in the financial sector not to enter into or to continue to participate in any transaction or business relationship with an Iranian bank known as McDermott or any of its branches. McDermott duly applied in the High Court under Section 63 of the Counter-Terrorism Act of 2008 to have the direction set aside. Now, by way of background, statements made in Parliament had made it clear that the reason for singling out McDermott from other Iranian banks was that it had been identified as having assisted Iran's weapons programs by providing banking and financial services to entities involved with them. The 2008 Act, again, does authorize closed material procedures to be held in this type of proceeding. But significantly, perhaps, it authorizes the holding of those proceedings before the High Court and the Court of Appeal. No reference is made in the legislation to the Supreme Court. Mr. Justice Mitting, who heard the application in the High Court, duly conducted a closed material procedure hearing, and he found against McDermott, and he delivered an open judgment and a closed judgment. McDermott appealed. The Court of Appeal dismissed its appeal, and although the members of that court had read the closed judgment of Mr. Justice Mitting, they declared themselves not to have been influenced by it. Unsurprisingly, when the matter came before the Supreme Court, one of the issues which arose was whether the court had power, in the absence of express parliamentary authority, to hold a closed material procedure. In particular, whether it had power to admit Mr. Justice Mitting's judgment and to hear submissions about it. Put broadly, the competing arguments on the issue can be summarized in this way. For the government, it was claimed that Section 40, subsection 5 of the Constitutional Reform Act 2005, that provision provides that the Supreme Court has power to determine any question necessary for the purposes of doing justice in an appeal. And it was submitted that Section 40, subsection 5 meant that the court must have power to hold a closed material procedure in an appeal from the decision of a lower court. For the bank, by contrast, it was argued that the absence of any express provision about the Supreme Court holding such a procedure was really determinative of the issue. And the pragmatic considerations that I referred to earlier, which weren't given the prominence that they might have been in the Arabi judgment, probably because it wasn't necessary, but the pragmatic considerations that came into prominence in the McDermott appeal concerned the structure and safeguards which the 2008 Act and rules of court made under the Act, the structure and safeguards that were put in place in relation to the holding of a closed material procedure. So, for instance, Section 62, subsection 2A enjoined the person making the rules to deal with this type of financial restriction hearing, to deal with closed material procedures. That person was obliged to have regard to the need to secure that the decisions which were subject of those closed material proceedings, that they were properly reviewed. And Section 67, subsection 3D, stipulated that if permission was given by the court not to disclose material, it had to consider requiring the Treasury to provide a summary of the material to every party to the proceedings and every party's legal representative. I describe those as pragmatic considerations because they, to me, represent the nuts and bolts of a system which dramatically altered the way in which trials were conducted. The 2008 Act had recognized that one of the central features of a fair trial could not be arbitrarily swept away without at least putting in place some compensatory, mitigating measures that sought to redress, to some extent at least, the palpable imbalance created by the denial to one party of access to crucial evidence. So one of the principal features introduced by the 2008 Act, which was designed to mitigate the disadvantage to the claimant, was the appointment of a special advocate whose function it would be to protect the claimant's interests. In fact, of course, special advocates are engaged in a wide variety of proceedings beyond financial restrictions. But the disadvantages of the system are many. They were described by Lord Dyson at some length in Al-Rabi. As I've said, special advocates are made aware of the closed material. They participate in the closed hearing, but they're expressly forbidden to disclose that material or even a gist of it to the party whose interests they purport to represent. In its report on counter-terrorism policy and human rights, the Joint Committee on Human Rights was scathing about closed material procedure hearings and the special advocate system in particular. The report indeed was based on first-hand experience of those who have actually acted as special advocates. And the committee's view was that after 5 years of its operation under various statutory regimes, the closed material procedure with special advocates was simply not capable of ensuring the substantial measure of procedural justice that was required. In an earlier report in 2007, the committee had said this: "After listening to the evidence of the special advocates, we find it hard not to reach for the well-worn description of it as Kafkaesque or like the Star Chamber. The special advocates agreed, when it was put to them, that in the light of the concerns they had raised, the public should be left in absolutely no doubt that what is happening has absolutely nothing to do with the traditions of adversarial justice as we have come to understand them in the British legal system. Indeed, we were left with a very strong feeling that this is a process which is not just offensive to the basic principles of adversarial justice in which lawyers are steeped, but it is very much against the basic notions of fair play as the lay public would understand them." Pretty severe criticism. But the criticism of the system of special advocates is probably, and ironically, most forcefully put by the special advocates themselves. In their response to the Justice and Security Green Paper, which, as you will know, is a consultative document issued with a view to introducing legislation extending closed material procedures to all proceedings that involve issues of national security. In their submission, the special advocates were, I suppose one would have to say, scornful of the system which they themselves operated. And in one passage they made the following observation: Our experience as special advocates involved in statutory and non-statutory closed material procedures leaves us in no doubt that closed material procedures are inherently unfair. They do not work effectively, nor do they deliver real procedural fairness. The fact that such procedures may be operated so as to meet the minimum standards required by Article 6 of the European Convention, with such modification as has been required by the courts so as to reduce that inherent unfairness, does not and cannot make them objectively fair. Now, the mitigating measures that I've described, which the 2008 Act, the Counter-Terrorism Act, proposed for closed material procedure hearings in the High Court and the Court of Appeal, were not, of course, provided for in relation to the Supreme Court. And that is so for the prosaic reason that the Supreme Court simply doesn't feature in that legislation. And as I've said, one of the issues which arose in the debate as to whether the court had power to hold a closed material procedure, and if it did, whether we should exercise that power, was whether Section 40, subsection 5 of the Constitutional Reform Act that I've told you about, whether that could be taken as signifying Parliament's intention that the Supreme Court should have a power to carry out such a procedure, while leaving it bereft of the structure and safeguards which were deemed essential for the other courts in which such a hearing is expressly permitted. As I've said, judgment in that case has not yet been given. I expect that it will be delivered fairly soon. But it's a matter of record, as Sally has mentioned, that by a majority, the Supreme Court decided that it did have power to institute a closed material procedure, and again by a majority, that it should admit and hear submissions on the closed judgment of Mr. Justice Mitting. The special advocate who had represented the bank's interests both before the High Court and the Court of Appeal made submissions to us in the course of the closed hearing. I don't want to be tantalizing, but that I think is all that can properly be said about Mcdermott at this stage. I have scarcely time to mention the case of Abu Qatada, but the wide publicity given to it makes it necessary that I mention it briefly. The Court of Appeal recently dismissed the appeal against SAIC's judgment that Abu Qatada should not be returned to Jordan, while there was a substantial risk that evidence would be given at his trial, which was the product of torture. It would be wrong for me to pass any comment on the correctness of that decision, not least because we are told by the press it will be the subject of an application for permission to appeal to the Supreme Court. When I left the Supreme Court this morning, the permission had not yet been received, but we are reliably informed by various newspapers that it is forthcoming. While I make no comment on the Court of Appeal judgment, it's right to record that it purported to follow the decision of the Strasbourg Court, which had made it clear that both it, that is, the European Court of Human Rights, and national courts should set their face against the admission of evidence produced by torture. Not simply because this is required so that the state can be seen to have stood firm against the conduct that produced the evidence. At least as compelling was the view that evidence produced by torture was intrinsically unreliable, unfair, offensive to ordinary standards of humanity and decency, and incompatible with the principles which should animate a tribunal seeking to administer justice. In that eloquent passage, I should say, Strasbourg was not uttering its original thoughts. It's a direct quotation from the words of the iconic figure of Lord Bingham, himself, of course, the product of Ulster stock. It seems to me that whatever the rights or wrongs of the decision of the Court of Appeal, the conclusion must resonate strongly with all who subscribe to the notion that we should not require those who are entitled to look to the state for the protection of their fundamental rights, we should not require them to accept a lesser standard of justice than we consider is the irreducible minimum of a fair trial. And so, although I have earlier disavowed any opinion on how the courts of the United Kingdom would meet the judgment of history, on how they have discharged their duty to stand between the subject and any attempted encroachment on his liberty by the executive, if I were pressed to make a prediction in the form of a school report, I think that I might say, good in parts, continued concentration, concentrated application required. Thank you for listening.